Hello and welcome back. I'm glad you're here. If this is your first time joining me, here's what the show is. The Conditions Report is a weekly series where we read the sky of policing the way a pilot reads the weather. Every episode follows the same structure. We start with the statutory climate. That's the constitutional and statutory baseline you operate inside. Then we move to the legal front. That's where real cases stress test the rules. After that, we shift to the leadership climate. That's the maxim you can carry into the field. And we finish with an extended forecast. That's the practical week ahead application you can use on the street tonight. The idea behind the show is simple. Policing is an environment, and that environment changes fast. The legal and cultural atmosphere moves. If you cannot read the sky, you'll get caught inside the storm. The goal here is clarity. See the system, understand the rules, make decisions that stand up in the courtroom and inside the police community. The Conditions Report is a project by Forecast Securities Group, LLC, the training consulting company I founded to help professionals in high-risk environments operate with legality, precision, and clarity. And before we begin, the disclaimer. This presentation is for educational purposes only. It is not legal advice. I'm not an attorney, and I do not represent any agency, department, or government entity. I speak only for Forecast Securities Group, LLC, and if you're dealing with an actual case, consult a qualified attorney. As you can see, the background has changed a little bit. Now that there's more than just me watching the show, I figured I would upgrade and improve. Additionally, if anyone has any feedback, I'm more than willing to accept it. I think growth is really important, and the only way to do that is to be a little humble and accept the feedback. But anyway, let's get into the show. Sometimes the law changes because an officer makes a catastrophic mistake. And sometimes it changes because departments develop bad habits. And sometimes, such as in People v. Ramey, a California case from 1976, the law changes because a group of officers did something that felt entirely normal in their time, something that they had been taught to do and something that their agency expected and something that no one would have questioned until a court finally drew a hard line. To understand why this case reshaped California law, we have to go all the way back to a quiet summer afternoon in Sacramento, 1973. On July 30th of that year, James Turner came home to find his residence burglarized. Several guns were taken, including a distinctive .38 caliber Smith & Wesson Airweight, the kind of firearm that stands out in burglary reporting, the kind of investigators often can trace if they know where to look. Turner was not a typical victim. He was a licensed private investigator and former security guard. Reporting the burglary to Sacramento Police Department was only the beginning for him. He did what investigators do. He started his own parallel inquiry. Turner talked to people in the neighborhood. He followed the leads. He made calls, and eventually he spoke with two individuals, Reed and Weaver. Reed told him that a man named Michael Ramey had purchased a stolen weapon. This was not rumor. This was not speculation. This was a direct statement from someone Turner trusted enough to follow. Turner knew Ramey casually, just enough to knock on his door. And so, 17 days after the burglary, Turner confronted Ramey inside his home. The conversation that unfolded had become one of those small, overlooked in law enforcement that carry the outsized weight of hindsight. Turner pressed him about the stolen gun. Ramey denied having bought it. Turner pushed harder. He said he knew specifically that Ramey had purchased the Airweight. That's when Ramey slipped. His words were simple. "Oh, that one. I didn't know it was yours." A moment of self-incrimination that changed everything. Ramey then admitted that he had the gun briefly, but claims a little too quickly that he had sold it to some white guy. He could not give a name. He could not give a description. He could not fill in the details that innocent processor could simply, easily fill in. And Turner, who had been watching human behavior professionally for years, walked out with the belief that Ramey still possessed the gun. He brought all of this information to a detective at Sacramento Police Department. Turner explained the burglary, the chain of inquiry, the conversation with Reed and Weaver, the confrontation with Ramey, and the incriminating admissions. The detective accepted Turner as a citizen informant, not a compensated informant, not a criminal informant, but a credible private citizen, providing firsthand information, and the detective concluded that there was probable cause to arrest Ramey for receiving stolen property. The California Supreme Court would later agree. So far, everything's clean. The officers had solid probable cause. They had a credible witness. It had clear statements. The investigative work was solid. This is where the error came. Detectives waited approximately 3 hours before acting on the information. He did not seek an arrest warrant. No effort was made to contact a judge, and there was no time pressure or evolving danger, no suspect preparing to flee. But in the early 1970s, warrantless home arrests were routine in California. Entire departments relied on long-standing interpretations of the Penal Code, Section 836, which allowed warrantless felony arrests on probable cause. The assumption, cultural, institutional, and reinforced over decades, was that home entries to arrest someone on PC alone were lawful, so long as the officer complied with knock notice statutes. So, 7 officers went to Ramey's residence. They approached the door, guns drawn, not as an act of aggression, but in accordance with their understanding of the risk profile of arresting a man believed to have been involved in a firearm-related burglary. They knocked. Ramey answered, and the officers identified themselves and displayed badges. What happened next is often reduced to a sentence in case books, but it deserves more attention. When Ramey saw the officers, he did not slam the door or flee. He stepped backwards into the living room, a quiet, controlled retreat that, in that era, officers interpreted as an invitation to follow. They stepped in after him, believing that they had the authority and obligation to maintain control of the situation. As he moved backwards, Ramey extended his arm behind a small portable bar. The officers did not know what he was reaching for. In a split second, where ambiguity and safety were colliding, one officer grabbed his arm to prevent him from accessing whatever was behind the bar. Behind the bar was a .45 caliber pistol. On top of it were 3 lids of marijuana packaged in cellophane, and near it were benzodrine tablets. In the room, visible on surfaces, were additional amounts of marijuana. But none of this evidence would survive, because none of it should have been discovered. The entry itself lacked constitutional justification. Ramey was arrested inside his home without a warrant. There was no exigency, no consent, and under evolving constitutional doctrine, that was enough to collapse the case. California had to create a mechanism, a pre-complaint arrest warrant, to prevent this from happening ever again. The mechanism became known as the Ramey warrant. The statutory climate is shaped by the Constitution. Article 1, Section 13 of the California Constitution mirrors the Fourth Amendment in protecting people from unreasonable searches and seizures. The home has always been the access point of that protection. Courts consistently treat the home as the highest rung in the privacy ladder, more protected than vehicles, more protected than public spaces, and more protected than any other environment officers regularly enter. California's legislature eventually codified the Ramey mechanism through Penal Code Section 817, which allows judges to issue pre-complaint arrest warrants based on probable cause to bridge the gap between investigation and lawful entry. It is not a formality. It's a constitutional safeguard designed explicitly to avoid mistakes that occurred in the Ramey's home. Texas did the same thing. Florida did something similar, and New York would do it later after Payton. Because the law consistently recognizes that entering a home is not merely tactical, it is a constitutional threshold. In the legal front, People v. Ramey sits inside a larger constitutional story about home entry. To understand its significance, you have to place it alongside other federal cases that came before and after. 4 years after Ramey, the United States Supreme Court decided Payton v. New York. In Payton, officers forcibly entered a suspect's home without a warrant to arrest him for murder. The Supreme Court held that the Fourth Amendment prohibits warrantless, non-exigent entries into a home to make routine felony arrests. The court called such entries the chief evil the Fourth Amendment was designed to prevent. Predicated Payton. California was ahead of the federal curve by 4 years. Then came Stiegel v. United States in 1981. This extended the doctrine. Officers in Stiegel had an arrest warrant for a fugitive, but entered a third party's home to search for him. The court held that they needed a search warrant for that home, and the arrest warrant was not enough. The ruling reinforced that warrants are tied to places as much as persons. Then, in 1990, Maryland v. Buey clarified that officers may do an inside home once lawfully present, a protective sweep, but only when articulable facts support reasonable suspicion that a person is present and poses a danger. It's a narrow allowance and one that applies only after lawful entry. Then came U.S. v. Dunn, 1987. This defined curtilage as areas intimately associated with the home, giving it the same constitutional protection. Officers who walk onto porches, enclosed patios, and side yards are already in constitutionally sensitive territory. In Kentucky v. King in 2011, police created exigency. If officers create a crisis by violating or threatening to violate the Fourth Amendment, they cannot use the crisis they manufacture to then justify entering a home without a warrant. When all of this is read together, the message is unmistakable. Entry into a home is not procedural details. It is a constitutional act that requires judicial oversight unless a true emergency necessitates otherwise. And Ramey, the case that birthed California's pre-complaint arrest warrant, fits squarely inside the trajectory. But the most persistent misunderstanding about Ramey is not doctrinal, it's a cultural one. For decades, officers have been taught that the purpose of a Ramey warrant is to get a statement before a suspect invokes. I was taught that, and I've actually heard that repeated on multiple occasions, even still today. That myth has no basis in the opinion, not a single sentence, not a footnote. There's no implication that Ramey is about statements whatsoever. It's about entry, which brings us to the leadership climate. Today's maxim is ego is a poor compass. Ego is a poor compass, and it's important to understand that ego, in this sense, is not loud or arrogant. It's quiet. It's familiar. It comes from the form of certainty. The belief that the practices that shaped our own careers are still reliable guides for officers today. Ramey's officers did not set out to violate the Constitution. They were operating inside the norms for their time. Their commanders believed those norms were sound. Their departments believed they were sound. The courts had not yet issued any rulings that would shift the legal landscape beneath them. They were certain what they were doing was the right thing because everyone around them was certain too. That's how drift happens. A profession can move away from clarity without anyone acting maliciously. Practices can become habits, habits can become doctrine, and doctrine can become tradition. And tradition can lock a department into a version of the job that no longer exists. We see the same dynamic today with leadership. Chiefs and captains and lieutenants who have spent decades away from a patrol car may still speak with the cadence of a 1990s or early 2000s era officer, when speed was praised, when decisive action was the marker of competence, and when the legal system had not yet articulated standards that we now live under. They might encourage officers to push the pace, to rush to action, to seize initiative based on instinct or reasonable suspicion, not out of recklessness, but out of a memory for a job that doesn't exist. But modern case law, including decisions like Barnes v. Felix, demands something different. When time allows, the courts expect patience. They expect articulation. They expect officers to slow down where they can move quickly only where they must. Urgency is still essential when lives are in danger. When killing is active, when serious bodily injury is occurring, or any other of the exigencies we've mentioned on this show before. When seconds matter, the Constitution has never required hesitation where we're sent to preserve human life. But urgency without necessity is drift. And drift begins when leaders rely on ego instead of clarity. The officers in Ramey were not reckless men. They were men guided by the compass they had been given, by a compass that was outdated, and courts corrected course. Today, the responsibility falls on modern leadership to ensure that officers are guided by a legal environment that they are actually operating in, and not one that existed when the supervisor last cleared a house or last made in-home arrest. Ego always points back to what you already know. Clarity points towards what the job requires now. A leader's responsibility is to know which direction they're giving their people. That brings us to today's extended forecast. Here's what the week ahead looks like. The Ramey rule remains a pillar in California home entry doctrine. The modern landscape expects officers to differentiate between urgency and opportunity. When lives are at stake, you move. When time and safety permit, you articulate. When you have probable cause and you need to enter a home, you get a warrant unless a true exigency exists. Electronic warrant systems have reduced the friction. Judges are readily accessible, And courts now look closely at whether you use the time wisely available to pursue constitutionally preferred path. The forecast is this: the law is asking you to be accurate, not impulsive. It's asking you to know the terrain, to read the constitutional weather. The profession has shifted, the scrutiny has tightened, and the expectations have risen. And when you approach the threshold, the question is never, do you feel ready? The question should be, do we have the legal authority? If you answer that question correctly, your case will survive the weather. If not, well, you'll be standing where Detective Garcia stood in 1976, watching a great investigation and all of his hard work fall apart because no one paused long enough to check the compass. Be deliberate, be precise, and be clear, because clarity is the shield that modern legal climates expect you to carry. I'm Don, and this has been the Conditions Report, Episode 9. Be the calm in the storm, the clarity and confusion, and always see you guys next time.